Well, good evening, everyone. I'm Mike Small, and I'm a long-time member of IRMA, and I'm also an analyst with an analyst company called Coppinger Cole, which has its headquarters in Germany. And today I'm hoping to talk to you about the impact of the Schrems II judgment on compliance and the cloud. So let me make it clear to begin with that I'm not a lawyer, and so I'm looking at this from a point of view of technology. But like all technologists today, and especially anyone who is involved in any form of compliance, the law has an important impact. Now, some of you might wonder why in England we should care about this odd judgment that's come from the EU Superior Court. And so my response to that is to say that we might have left the EU, but many of the large organizations still have much dealing with the EU. As when I worked for a large multinational organization, I had people working for me across Europe as well as across other parts of the world. And so if you have customers, if you have staff, or if you are doing business with the EU, then the compliance with the EU regulations regarding privacy matters. And so let me start off by showing you the impact of non-compliance. That in fact, in April 2021, the Portuguese Data Protection Authority gave the National Institute of Statistics in Portugal that was conducting work around the census 12 hours notice to cease and desist from using a US-based cloud service provider. Now that's a pretty dramatic thing to happen, and you could well say that that this is almost complianceware, which is disconnecting you. And so understanding the potential impact on your business of a failure to comply can be quite a significant issue. And so what I want to now do is to sort of take us back and to understand where this came from. So I'm sure that we all remember GDPR, and GDPR was a regulation which was to do with how personal data was in fact processed fairly and legally, and in particular the personal data of residents within the EU. And all that was passed in 2018. And at the same time, in the UK, we passed a Data Protection Act which mirrored that. Now, since we left the EU, there has been a period of transition and negotiation going on about how all this works. But the point is that in the meanwhile, there was also something happening. And many of you may remember Schrems I, which was this judgment and case related, was taken by this Austrian law student and activist called Maximilian Schrems. And he complained about Facebook, who were holding his data in Ireland, and they had been transmitting it without his knowledge into the US, and he objected to this. And the result of the first judgment was to to nullify the then existing US legislation that allowed them to gain exemption from compliance. However, he was still not satisfied, and so he took it a second time to the European Court of Justice. And the result of that was that the judgment hinged around whether or not the US Privacy Shield provided adequate protection of personal data. And the argument was made that, well, since a contract, which is a contract between you as a cloud service user and a cloud service provider, does not apply to the government that controls the jurisdiction within which the cloud service provider operates. And so the result of that was that the Privacy Shield, which was the way in which the cloud service providers were claiming that they were compliant, was nullified. And so what did that mean? Well, this was a judgment in the middle of 2020, and nobody really seemed to understand the implications of it. But in 2021, the European Data Protection Board set out what it means, and that is a salutary set of statements. And I'm just going to review what those are saying. Now, so I want you to remember, this is not about the legal aspects of this in terms of me as a lawyer or whatever speaking. This is me as a technician and technologist speaking. And so the European Data Protection Board, it produced a really interesting report which came up with a set of use cases. And basically, the result of that was that their advice and their recommendations are that the the processing of personal data in the clear was not permitted by most service providers outside of the EU. That the standard contractual clauses, which most of the large cloud service providers relied on, was not sufficient, and nor did binding corporate rules, which were effectively legal agreements between different divisions of a large organization. And this is that what was actually required was that if this data is being transmitted, if it is being moved outside of the EU or compliant third countries, that supplementary technical measures are needed. So what I'm really going to talk about in this presentation is what those supplementary technical measures are and what it is that the various vendors in the field are offering. So the measures that they propose are that encryption is good, providing the keys are retained by the person or the organization that that exports the data, and that you need to have good, strong, state-of-the-art encryption that is properly implemented. Pseudonymization is good, providing that takes place prior to transfer, but not all pseudonymizations are the same, and so you have to choose the pseudonymization correctly. And the third and interesting idea is what they call split processing or multi-party computing, and I will talk about that later on. And pseudonymization is in fact a form of split processing. Now, so those are the measures, and what has happened is that if you look at the examples that they give, and they give three or four different examples that you can transfer to cloud service providers or other processes which have access to the data is not allowed. And that's really interesting because that is a prohibition that relates to business processing as a service. So if you have, what that seems to mean is that if you have, say, healthcare data or other kinds of sensitive data, or even human resources data, which you want to have a third party provide a help desk or something, then you're in some trouble because you're not allowed to let the people in the remote country access that. And in any case, remote access to data for business purposes. So if you have some kind of remote service provider, then that would not be allowed either. So these are pretty draconian requirements. And so the question is, what can we do about it? Now, to start with, I'm going to talk about one of the things that, as an analyst, suddenly I became confronted with, which is that a lot of organizations started taking an interest in what they called the sovereign cloud. And there's been a lot of talk about the sovereign cloud. And in rough terms, this means that somehow or other, you have a cloud service that is provided from the jurisdiction in which your data has to be regulated. So in terms of this example, we're talking about EU sovereign clouds. Well, is it like that, or is it more complicated? So when you look at what sovereignty means, in fact, sovereignty has different areas potentially associated with it. And everybody gets terribly interested in what is called data sovereignty, which is the jurisdiction in which the data is located and processed. And the Schrems II judgment sees a risk associated with this, and that risk is that a government can use their sovereign powers, their extra powers, to override contracts and demand that the service provider hands over the data. So, for example, in the US through the US Patriot Act. But that is not the only form of sovereignty. Another form of sovereignty is what you would call operational sovereignty. So you may have the data held within the EU, but if the systems are being administered from a third country, if they are being administered from America, if the administrators are located somewhere else, then those administrators could be subject to some kind of legal requirement to hand over data, again, leading to this risk of legally unauthorized access. The third area, which is a bit more obscure, but it is the feeling that if you are using one of these systems that is provided based on proprietary APIs and proprietary technology, that if you fell out with that jurisdiction, then could they limit your access to that particular technology? And this is a concern because most of the large hyperscale clouds are based on proprietary technology. So if you were to use those clouds, then you are locking yourself into something that you may find difficult to replace. And the final area is the sovereignty, the ownership of the infrastructure. So let's say that the cloud service provider said, well, we're going to locate the data center in your country. We're going to allow local administrators to administrate it, but we still own it. So there is the risk that through ownership, they could legally refuse you access because they could say, well, we own it, you can't have it. And indeed, this is a challenge because nearly all of the major hyperscale providers now own a vast amount of infrastructure. You know, the intercontinental cables and the intercontinental telecommunications is owned and implemented by the hyperscalers. So those are 4 areas that you might be concerned about. And so if you say, what is a sovereign cloud, you've got to look at all of those different aspects. Now, just to sort of give you an interesting take on this, that if you look at the different kinds of claims that the vendors make, the hyperscalers, that nearly all of them have some kind of a government cloud, but that is usually based in the US. And so if you're a US federal agency, you can get a US government cloud. That sort of gives you data sovereignty and operational sovereignty. Data center location really only gives you data sovereignty. If you say, well, we'd like a private cloud, then that private cloud, because it is administered by the cloud service provider, may or may not give you operational sovereignty, but it almost certainly doesn't give you technology or infrastructure sovereignty. Nearly all of the cloud providers now have some kind of cloud in a box. You've got the Azure stack, you've got IBM Satellite, and various offers from AWS, which allow you to have your cloud in a box, either as software or as an appliance. And once again, if that is managed by the cloud service provider, then it's not giving you operational sovereignty. So one of the options that, in fact, Google was announcing quite recently was that they were going to make available a version of the Google's cloud stack, which would be administered and managed by one of their European partners. And that would solve this. Standards and open source is being put forward as the answer to the problem of technology sovereignty. So basically, we have a challenge that to meet all of those different requirements really comes down to having something which is the most things are where you have a cloud service provider that is locally provided. So if you have an EU sovereign cloud, and in fact, I did an analysis document, which you can find through the link there, where I looked at about, it was somewhere in the order of 10, I identified 10 to 20 European cloud service providers. And these guaranteed you data residency, operation, and legal governance. But none of them were able to provide the comprehensive functionality that you can get from a cloud service provider. And the fact that it was managed and located in the EU did not absolve you of the need to take care of your data and to take steps to implement the technical security measures, because the stuff can still leak through errors and omissions that you yourself make. Now, so that's interesting. And one of the things that has come up, and I don't know how many of you are aware of this, is the Gaia X project. And this was set up in 2019 by France and Germany with the objective of to create a federated and secure data infrastructure. Now, interestingly, this is something which most of the hyperscale providers have joined. And the idea is to somehow or other to be able to create a service which can be trusted within the EU. And it's doing this through shared elements and through common interfaces, standards, and standard services. So they have some of the European providers are in fact engaging in this. And certainly there is a lot of lobbying going on around it by the hyperscalers. So this is work in progress, and we're waiting to see the outcome. So that was a little diversion, which was to say that we don't really have a significant presence of European providers that could satisfy the needs for the sovereign cloud. And indeed, although there are some big ones, there is still the hyperscalers have the majority of the business. So how can we get round that problem if we want to use a hyperscaler? And the technical answer, the technology answer, is to do with confidential computing. And I'm also calling it zero trust data protection. And in order to deal with this, in order to have these effective controls in the face of these new threats, we actually need to protect the data while it's in storage and while it's in transit, and also while it is being processed. And one of the areas that people have forgotten is that while the data is being processed, it is also vulnerable. And there are lots of vulnerabilities to do with this, not the least of which is the common use of a single user and password when you are attaching from your application to a database. And so what I'm going to be talking about is what you can do and what is on the offer from the vendors for protecting your data while it is being processed. And so there are a number of solutions. And one of the interesting ones is kind of a rather an old one. 10 years or more ago, I was looking at what were called cloud access security brokers or secure web gateways of some form or another, which were encrypting or tokenizing data before it was sent to the cloud. And in particular, this was to do with one of the large CRM providers, which was the concern. And the interesting thing with that is that this has an appliance which is kept on your premises, which somehow or other understands the structure of the HTTP that is running to the cloud service, and it finds the bits in it that you need to encrypt. It encrypts them and replaces them with some kind of a token, and that is claimed to work, and it may well work for some of the things. So that is an old and understood way of doing things. Indeed, this is also very relevant because that is the way that many of the backup services work. And in the backup services, then it's a different problem because most of the backup doesn't require you to be able to use the data in clear, but not always, because if it's backup and restore or disaster recovery, then you may well have to be able to reuse it. The second approach is that Microsoft released this thing that they call double key encryption. And double key encryption is, if you will, a supplementary measure, in the sense that Microsoft already make the point with their Office 365 group of products that they already automatically encrypt the data, whether you like it or not. But of course, that encryption is done with keys which they control. And so they wanted to provide you with a system that allowed you to have your own key. So what you can do is, if you buy the right licenses, you are able to encrypt the data at your end before it goes to Office 365. And your Office 365 installation works in your organization, and you can read the data in your organization. But Microsoft can't, because they never have access to those keys. And that works to an extent. It works as long as you use the apps, but it doesn't work if you use the cloud-based apps. But one of the limitations of this is that you can't use the Office 365 cloud-based applications. Indeed, that may or may not be a problem for you. It also has an impact on the Microsoft rights management stuff. So you can use it, but it's not without its problems. Now, another thing which many of the cloud service providers offer is what they call bring your own key. So bring your own key allows you to retain your encryption through a key that you control, which usually is put into some form of hardware security module that is offered as a service. And that then allows you to control the encryption and to manage your keys through one of the secure key management protocols. And this is based on a guarantee that the hardware security modules are evaluated to be tamper-proof. And so clearly that would override any kind of cloud service provider encryption, but it does not deal with encryption in transit. You've got to do that as a supplementary way. And it also does not allow you to encrypt the data while it is being processed. And just to sort of kind of rub away at that particular thing, if your database is encrypted, but your application is processing that, then once the application reads the data, it will decrypt it through the application protocols while it is being processed. So once it is in the memory, it will then be available to memory scrapers, of which there are many available. So what the answer to that is what's called these trusted execution environments. And so both Intel with the Software Guard extension and AMD have provided chips which are evaluated to provide a secured enclave within the chip, so that you can arrange that the data within the processing area, within the processing enclave that you are using, is decrypted, and that decryption is not, and that decrypted area is not accessible due to hardware controls by any other processes. And hence it means that a normal RAM scraper will not be able to get hold of that data in clear. And that allows processing to occur, and it allows the data clearly to be also encrypted at rest. It clearly doesn't cover the in transit, and it depends upon the use of these trusted enclaves. Now, it doesn't help you with software as a service unless the software as a service it guarantees to use those enclaves when it is doing the processing. And there is only one vendor that I know of that has started to say that they would provide a database management, a managed database as a service, which is run within that enclave. Now, pseudonymization is, in fact, another solution. And like I say, not all pseudonymizations are the same. And so there is a definition of what is acceptable as pseudonymization within the EU, which comes from ENISA. And I'm afraid I've forgotten to include the link, but you can find a link to the ENISA pseudonymization. Now, pseudonymization means what you do is you change the data for the data that is being obscured for some other data which only you can reconstitute. And there are two kinds of pseudonymization. There is one-way and there is restorable. And one-way pseudonymization, you can't actually ever get the data back. And in the restorable, you keep a secret and you are able to restore the data. And the trick with the pseudonymization is to somehow or other change the data in a way that makes it processable. Now, some of the ways that do that are in fact very crude. So if you said, well, if we change the names that people, if we have a list of names, if we then do some kind of random scrambling of names, that's not good enough, because that would allow you over a period of time to work out what the set of names was, and then to start to put it together with other information that was scrambled in that way in order to kind of decrypt it. So it has to be a more sophisticated approach than that. Now, the good thing behind this is that the modern technology, which everybody's worrying about and everybody's trying to exploit, which is machine learning, well, machine learning doesn't really care. So machine learning doesn't have any wish or understanding of the data that it is given. And so machine learning works perfectly adequately on pseudonymous data, which is the good thing. So pseudonymization is in fact a very good solution indeed. It is the one that is advised by the UK Information Commissioner. Now, looking into things that are a little bit more exotic, for some time now, there's been a lot of talk about homomorphic encryption. And indeed, there are implementations of it. And homomorphic encryption is the idea that you could somehow or other encrypt data in a way that when you process the encrypted data, that when you decrypt the result of that processing, it in fact gets the right answer. And so depending on how many operations you are prepared to pay, you need to have implemented. So do you just want to sort it? Do you want to be able to select it? Do you want to be able to perform mathematical operations on it? And so on. The cost of that encryption increases. And indeed, probably one of the leaders in this area is IBM. And IBM say that they've managed to get it to the point where that it is only 40 times more computer intensive than if you used ordinary encryption. And indeed, you may then have to change the applications to implement that. Now, That's not to say that it's not going to work in the end, but at the moment, it's not something that I would say is an obvious solution for everybody to exploit. Whilst, say, something like pseudonymization is more readily available and doesn't have these problems. Now, the other interesting thing is the secure multi-party processing. And to give you the example of this, which some of you may have come across, and if you have, please forgive me. This is that in January, the bankers all get their bonuses. And well, one of the things is that usually if you're in a position where you're getting those bonuses, you are forbidden by your contract from telling any of your colleagues what the bonus you got was. But so imagine a group of bankers who want the person who got the biggest bonus to pay for the drinks at the party. Is there a way for those bankers to negotiate between themselves without disclosing the modus that they got to the others, that to work out who got the most? And indeed, there are a set of mathematically provable protocols that allow you to do that. In a more practical and pragmatic example of that is that there is, in fact, a system that is running based on the replacement of the auctioneer in auction sites, where an auctioneer is the neutral party who makes sure that the different bidders are able to make their bids, even by proxy, without disclosing what their maximum is, and sellers can get the fair and the greatest value. And that can be achieved through a secure multi-party protocol. And indeed, there are auction sites that are running with that in Europe. So I've had a quick run through some of the examples, and here is a way of looking at whether or not and how well these work for different applications. And first of all, that if the cloud service provider says, well, we encrypt the data, and they are not a European one, then unfortunately that is insufficient. But if all you want to do is to hold backups, then if you encrypt the data before you send it to the cloud using a suitably secure encryption algorithm and keep control of the keys, that's fine. If, however, what you wanted to do was to have disaster recovery to the cloud, then it is not sufficient. So if you imagine the situation which some vendors will offer you, which says, we will take a copy of your database and your application, or a snapshot of your virtual machine, and if your local systems break or are unavailable, you can seamlessly fail over to a virtual machine running in our cloud service, then simply encrypting the data is not sufficient. If you look at infrastructure as a service workloads, then trusted execution environments or pseudonymization, again, is what you need. If you're using software as a service, then what we have seen is that for some kinds of software as a service, particularly where you have a client that is being used, then you can use encryption, providing you do it on premises. But that is only for the data. If you need to be able to execute it, then you need pseudonymization. So those are some of the examples. Now, what we've done here is we've focused on one little area. And what I always like to say to people is, you can't pick and choose these individual areas, that you need to look at data protection in the whole life cycle. And this is based from where you acquire the data, when you use the data. We are talking here about that one little area which is secure. You still have to control access through authentication, authorization. You still need to be looking at whether or not there are people trying to attack your data. You need to be able to know that if you lose your data for all kinds of reasons, such as failure or ransomware, that you have ways of overcoming it. And increasingly, deception is becoming a way of dealing with it. And finally, you need to be sure that when you come to the end of the life, that you have a way of disposing of it securely. And so, to kind of summarize, what has happened is that Schrems II has brought out this risk, and this risk that third countries can intercept your data legally if you outsource your processing there, has an impact through the judgment of the European Court of Justice on personal data. And if that's the case, then it also has an impact potentially on your intellectual property. And you need to think carefully about what that means. Now, one of the solutions that is put forward to all of this is cloud sovereignty. And what I've tried to illustrate is that sovereignty is more than just data sovereignty, and you need to think about all the sovereignty risks. And many of the sovereign clouds, in fact, don't provide the functionality that the major hyperscalers can. And so we are in a position where, whether we like it or not, there is an enormous amount of dependency on this global supply of computer services. And from the perspective of data protection and protecting against some of the risks of sovereignty and some of the risks that are identified by the Schrems II, confidential computing helps. But that is only if it is part of a full zero trust approach to data protection. So with that, I'm going to say thank you very much for your attention and hand it back over to Andy, who will be able to take over now. So Andy, would you like to unmute and take over? Right. Okay, well, if anybody's got any questions, are there any questions in the chat? Otherwise, if I can figure out how to unmute things, then I might be able to help. So does anybody have any questions? I believe you should be able to unmute yourself if you have. Otherwise, you can use the chat window. Andy, have you anything to say? I can see you're unmuted, but I can't hear anything.
Hello, Mark. Thank you very much for this very interesting subject that you presented. We had some 41 people registered for this webinar, but at the most, we had 22 people attended. So I would like to ask if anyone has any question, please.
So I can see that Rosie Nunn said it would be great to hear more about confidential computing offerings on the market. Well, what I can say is that if you look at the Kuppinger-Cole website, you'll be able to see the research that we have along that lines. Otherwise, in a sense, I tried to explain what the different options are. And if you look at the different cloud service vendors, you will be able to see what they are providing of those things. And then, of course, you will find that some of those cloud service providers have different answers to it. Many of them will offer you enclaves. Some of them will offer you different kinds of encryption. None of them that I know of offer pseudonymization directly, but there are data protection offerings that cover different kinds of pseudonymization. And these are now being sold as, if you will, separate products.
Any more questions?
Okay, well, so I guess this has been recorded. And so, Rosie Nance, it sounds like there's no perfect match. I think that is a very fair assessment. I think that is a very fair assessment of the situation. And you have to look at the different things that are on offer and choose what is appropriate for your particular case, and make sure you work with your lawyers and your data protection officers to come up with the right solution for your case. So if there's no more questions, then Andy, I'll say thank you very much, and thank you for setting this up in the first place. And thank you to everyone for your attention and your nice questions. So Andy, can you explain where to find the recordings?
Yes, the recording will be up on YouTube within a week or so, hopefully.
And I've also sent a copy of the slides, which
That's correct.
you'll be
I
posting.
received them today. Yeah.
Yeah.
Thanks a lot.
Okay. Well, thank you very much, everyone. Thank you, Andy.
Thank you very much, Mike. I would like to add something here. Probably it's a present from British Computer Society to those who are not members and they would like to apply for membership. They are offering a 20% discount on the membership fee. So if anyone is interested to join BCS, please contact either myself or Dergash, and we will send you the discount code.